Ohio versus Brian Keith Taylor. Are you Brian Keith Taylor appearing there from the jail?
Yes, sir. Yes, Your Honor.
All right.
Okay.
Just a minute. We have to be quiet. This is case number 24-0137, State of Ohio versus Brian Keith Taylor. This is a pretrial being conducted by Zoom. The defendant's been indicted on 3 counts of aggravated trafficking and 3 counts of aggravated possession of methamphetamine. Mr. Taylor's attorney is Dennis Kirk, appearing from his office, appearing from the prosecutor's office, Prosecutor Collins. This is a final pretrial. I believe we have a trial date set for April the 7th. Now, I believe that discovery was filed. There's no, Mr. Kirk, did you file a compliance with discovery?
I did, Your Honor.
Okay. Well, we pulled these files last week, so we, actually I see over here there's a red jacket. I see them. Yeah, okay. And then it looks like the state filed an additional discovery this morning with a lab report on it. And you received that?
I did receive that. Yes, my client's not yet aware of it, but I will take that out to him.
All right. And I don't see any pretrial motions filed, or did you file any?
I did not.
All right.
I did not see the warrant for any, so I did not file any.
All right. Now, what's the status of the case then in terms, I know we have a trial set on the April 7th, so that's actually inside the 14-day window, but I believe that this was the best we could do on the scheduling date. So what's the situation here with this case, counsel?
It's protected.
I have made my client aware of his plea offer. We did actually negotiate on that. I have made him aware of the 14-day rule. Also, the form to basically I forget what the technical term for it is, but basically the plea refusal form, gone over that with him as well. He does not wish to sign that form, but has not necessarily stated he wants a jury trial either. He did want me to go back to the state with some additional things, which I did, and they declined to change the offer. So at this point in time, I'm not sure what he wants to do. He's never given me
a decision.
The process, this process here, this pretrial hearing, I got motions. I'd like to file.
Well, you're not representing yourself. You have an attorney. And so,
I know that.
Well, wait a minute. Just wait a minute. I'm going to address this. And under the rule, motions, if you have an attorney, only your attorney can file a motion. So if you prepare something that you want to file, I have ordered our clerk's office not to accept those. They will not accept them because you are not representing yourself. The only way you can file a motion is if you represent yourself, in which case that would be a huge mistake, and you haven't asked for that, and there's be quiet, don't interrupt me when I'm speaking. I'll give you the chance to talk. You just be patient and listen, okay? One of your problems may be that you want to speak instead of listen, and that's a big mistake too. So, getting back to my point is that there's not what's called a hybrid representation system in Ohio, and that's a criminal case. The defendants can't file their own motions. Now, your attorney's indicated that he has reviewed these with you and didn't find anything that had any legal merit, arguable merit that he could file. And under the rules of law, attorneys aren't permitted to file frivolous motions just because their clients think they should. They're the attorneys. They're the ones that know the law. They're the ones that know the rules of professional conduct. They're the ones that are bound by it, not a defendant who wants to.
Welcome back, everyone. And buckle up, because today's case is one of the most infuriatingly hilarious and legally fascinating courtroom moments you'll ever see. On one side, we have a * no-nonsense Ohio judge with zero tolerance for foolishness. On the other, a defendant so convinced he's a legal genius that he decides to challenge the system armed with Google knowledge and misplaced confidence. This is a classic case of asterisk when you think you're a lawyer, but your note will watch how the judge masterfully dismantles his self-proclaimed legal theories, all while trying to maintain courtroom decorum. There's tension, ego, and pure courtroom drama, but also a valuable lesson about respecting the process and not letting pride become your downfall. That make sure you stay until the end, because the judge's final decision, let's just say it's
file any kind of number of motions that based probably on what you've seen on TV or in the movies, which is, again, a real big mistake to believe that kind of crap. So that's where we're at. Now, going back to my question, Are you rejecting the plea offer?
Yeah.
Yes? Okay, then we will have a trial on April the 7th. All right, so does the state expect this to take more than 1 day?
No, the state expects this to be finished in 1 day.
Okay. And you agree with that, Mr. Kirk?
I would agree with that, and I would note just for the record, I've been given no names, addresses, phone numbers of any witnesses, so I don't think we'll have very many, if no witnesses at all.
Well, if there's going to be any witnesses, Mr. Taylor, you have to give those to your attorney so that he can file and respond. Those will due by today, so if you've got them, get it to him right away so he can give them to the state. I'll give you till tomorrow to do that. Now, anything else that we need to discuss in this case?
Yeah, I'm gonna ask to have my attorney removed, and I got grounds here. I asked him to file a few motions which are legitimate. I mean, this ain't from TV, this is from going through the law book and studying day in and day out. Everything I got the case numbers, case laws, I got.
Motion, what kind of motions are you talking about, Mr. Taylor?
But one is a motion to suppress. One is, I got one here, it's
motion to suppress, but this is I believe this is a undercover buy situation, isn't it?
It is 3 buys.
Okay, so I don't know what kind of motion to suppress would be appropriate. What do you think could be suppressed?
It'd be,
well, if you know some.
Before we jump into court, I've got to hand it to this creator, slipping in that sponsor like a pro. But honestly, the timing is kind of poetic. We're about to watch a defendant expose his own personal data to a judge, metaphorically speaking. While Aura's protecting people from hackers, this guy, he's voluntarily hacking his own defense, and it raises an interesting point. In a world where we guard our online identity so carefully, why do so many defendants completely disregard protecting their legal identity? Stay tuned, because we're about to see what happens when pride meets prosecution.
Now, I've got you telling me there is, and I asked you what it is, and you can't tell me.
I asked you to file this motion, and
I know that. I'm saying is, what is it you think should be suppressed and why? What's the legal basis for it that you, being a non-lawyer, has come up with that an accomplished lawyer has not?
got from my paperwork here. Trying to be organized here at the same time.
So you have an answer. What is it you would seek to suppress?
I don't know.
Pardon me?
I don't know.
You don't know? Okay. Anything else you want to bring up?
I'd like to have my attorney move from the case and have another one, please.
Wait a minute. I'm having trouble understanding you. I can hear you.
I'd like to remove my attorney and get another one.
Okay, well, you have until April 7th to get yourself a new attorney. If you want to get a new attorney, you can do that. You'll have to hire them because you didn't hire Mr. Kirk. You didn't have the money to hire an attorney, so I appointed him for you. So, he's your attorney unless you get a new attorney. But if you do, they need to be ready to go to trial on April the 7th.
I can't get another court-appointed attorney. I can't afford an attorney.
No, you have a court-appointed attorney. I've given you a court-appointed attorney.
But he's not representing me.
Yeah, he is. He's representing you, and he's had conversations with you and discussions. You don't like what he's telling you. I get that. If I were in your position, unless they were telling me you're going to walk free and the state's going to give you a written apology and $1 million, I wouldn't be happy either. But, he's not going to do that. So, unless you can tell me why he is not, he shouldn't be your attorney, then you've given me no reason other than the fact that you don't like what he's saying, and he won't file motions that aren't proper, which is no attorney would file. So getting you a new attorney would not mean anything because a new attorney wouldn't be able to file frivolous motions either. And if I gave you any attorney who knows what they're doing, they're not going to do anything different than Mr. Kirk is. Mr. Kirk's been doing this a long time.
Here's where the tension begins. The judge immediately establishes control, calm but authoritative. The defendant, Brian Keith Taylor, faces serious charges: 3 counts of aggravated trafficking and 3 counts of possession of methamphetamine. The tone? All business. Notice how the judge keeps things procedural, verifying discovery, confirming deadlines, and checking compliance. Everything's standard until the moment Mr. Taylor tries to speak up. That's when this polite courtroom starts turning into a one-man stand-up show of legal delusion. And trust me, it escalates.
Now, anything else you want to bring up?
Yes, I have grounds, man. I haven't.
I asked you what your grounds were, and you didn't tell me anything. You said you didn't know on suppression.
Don't be respectful. Wait till you're done talking.
I'm sorry, what?
Don't be respectful, man. Wait till you're done talking. You got only once for interrupting you.
Okay. I asked you to answer my question, and you didn't when I asked you what your grounds were. Now, I'm not going to give you another attorney. If you want to get a new attorney, that's up to you. You feel free to do that. You'll have to hire that attorney. But I don't know who told you that you're entitled to get more than one attorney because the court has appointed you an attorney. Mr. Kirk is qualified and competent and experienced and knows way more than you'll ever know about the law. So just because you've been in court a few times doesn't mean you know anything about the law. Just because you got a book you can read doesn't mean you know anything about the law.
Here it is, the classic I got motions moment. Every judge's favorite. This is where defendants who binge legal dramas start believing they've unlocked the secret to courtroom domination. Here's the thing. The judge's reaction is masterclass patience. He doesn't yell, he educates. He reminds Taylor that Ohio law doesn't allow hybrid representation. You either have an attorney or you represent yourself. There's no halfway lawyer option, and when Taylor interrupts, the judge drops the hammer. Calm, controlled, but cutting. One of your problems may be that you want to speak instead of listen.
Is it myself?
Well, that would be the biggest mistake you've ever made in your entire life. Based upon what you've been telling me, I don't think there's any way in the world you could represent yourself. Pardon me?
I haven't been able to tell you nothing.
I can't understand. You're mumbling.
I haven't been able to tell you anything.
Well, you're not the attorney. You're on trial. You don't get to participate in your defense because that's what an attorney is for. That's why you have one.
But am I allowed to have a fair and just defense?
Oh, absolutely, and that's what you're going to get. We'll have a fair trial. We'll have a jury, and we'll have a trial.
I don't have all my discovery. I'm missing 12 things that I'm undiscovered. I'm begging for.
Well, he's got the discovery. Well, let me explain here, Mr. Taylor. I met with your attorney and the prosecutors before this hearing, and he kind of outlined to me some of the things you're talking about. As I understand it, you have everything of any importance. I think he said you had mentioned that you didn't have a copy of the resume of the BCI analyst or something, which is minor. It doesn't mean much. He can get that to you. He will get that to you. But the other things that you want, my understanding, he's given you more than what most defendants get in these kind of cases because usually there's a counsel-only discovery restriction. But since the identity of the CI is known, apparently they have let you watch the videos, right? You've watched the videos of what they say are the buys, right? And then you've gotten copies of everything that he has, pretty much. Is that correct, Mr. Kirk?
That is correct.
So let's pause for a second. The defendant just rejected the plea deal, a potentially life-altering decision, and he does it with zero plan. No witness list, no legal motions, no coherent argument. This isn't strategy. It's self-sabotage wrapped in misplaced confidence. Meanwhile, the judge is trying to keep this circus on the rails, setting deadlines and maintaining structure. You can almost feel his internal monologue saying, "Why do I even try?" But the beauty of this scene is that it shows the discipline of the court system. Even when defendants spiral, the process stays professional. That's justice in motion.
Something to do. So what? We still got 10 or 12 days to try. But again, you're not going to be the one that's going to be questioning the witnesses and presenting evidence and making arguments. That's what your attorney does. Pardon me?
Well, I'm afraid of.
I would be afraid too if I were on trial, but that's not why we're here. This is a final pretrial, and we're ready to go to trial. The court, we're going to send out our jury notices today. State's ready to go, and you're going to be ready to go unless you get a new attorney. And again, you're not going to get You know, maybe you can find somebody to be willing to take the case and go to trial on the 7th, but, you know, that's going to be on you. You know, if you want another attorney, you can get one. But all this stuff you're telling me doesn't amount to a hill of beans, as my dad would
I
say.
represent myself.
Pardon me?
I represent myself.
Well, if you want to do that, how are you going to do that? What do you know about the law?
I don't know that much about the law, but.
And so you want to go to trial not knowing much about the law against a prosecutor that does know the
I
law?
think my percentages would be higher, yes.
Pardon me?
I think I would have, my percentages would be higher, yes.
Well, I can't understand what he's saying.
He
Yes.
said his percentage would be higher. His percentage of winning would be higher if he.
Oh yeah, what do you think that would be?
I don't know.
Well, give me the odds, and I'll take that bet. Because you're absolutely 100% wrong. You know, everything you're saying here is exposing the stupidity of your position. And for me to allow you to represent yourself.
One of the most predictable turns in these kinds of cases, though I want a new lawyer card. It's a desperate move we see far too often. When reality starts closing in, defendants blame their attorneys instead of their action to listen carefully. Taylor's reasoning is textbook pseudo-law. He says he's been studying day in and day out, has case numbers and case laws, and believes his attorney is ignoring legitimate motions. In other words, asterisk, he's deep in Google Law School and the judge knows it. This isn't arrogance anymore. It's self-destruction disguised as independence. This exchange is brutal and hilarious. The judge's sarcasm cuts like a scalpel. If you know so much about the law, you should be able to answer that question when Taylor can't explain his own motion. The courtroom dynamic flips from defendant versus system to student versus teacher. What's fascinating here is how the judge balances mockery with control. He's not just roasting Taylor. He's forcing him to confront his own ignorance in real time.